powering innovation, advancing knowledge, and practices in intellectual property rights. I welcome you all to the last day of the Faculty Development Program. Our resource person of the day is Dr. Poonam Das, ma'am. She is an associate professor at University of Delhi, and today she'll be dealing with IPR and the cyberspace. I welcome you, ma'am. Now I would like to request Shyamjeet of LLM first year, Department of Law, to introduce our resource person.
Well, good morning all. Dear esteemed guests, students and faculty members, it's our pleasure to introduce Dr. Poonam Das, Assistant Professor of Law at LC1, Faculty of Law, University of Delhi. Dr. Das holds a PhD and LLM from Faculty of Law, Delhi University, and has a strong academic background in cyber laws, intellectual property laws, and international law. With over 14 years of teaching experience, Dr. Das has taught various subjects including intellectual property law, cyber laws, public international law, and administrative law. Moreover, she has presented papers at national and international conferences, including the WIPO WTO Collegium for Teachers of Intellectual Property in Geneva, Switzerland. Dr. Das has also supervised several doctoral and LLM dissertations and has published articles in national and international journals. Notably, Dr. Das has received several honors and awards, including the WIPO WTO Fellowship for participating in Collegium for Teachers of Intellectual Property at Geneva, Switzerland in 2010, and the Texas Instruments Fellowship for participating in the Summer Institute at CSRIP, University of Washington, USA on patent laws in 2005. Today, Dr. Das will be taking a session on the topic IPR and cyberspace. We welcome you, ma'am, and look forward to your insightful discussion. Thank you.
Thank you very much, sir. I think a lot of introduction was given regarding me. I'm still a learner, and since the cyber law is a developing subject, including IPR, so I think today also I'll learn by interacting with the participants and all of you. I don't know how much knowledge I have, but knowledge comes only when you share it with somebody and interact. So something I learn from you, and maybe you'll learn something from me. So let me share my presentation. This problem which is coming.
Or else, ma'am, you can WhatsApp me the PPT. I will make an arrangement for the presentation.
Okay. I'll just see if even whether it can share the screen also.
Okay, ma'am.
Let me try once again. If it is possible, then I'll send it to you. No. It's a problem which is occurring. Okay, I'll send you the presentation.
Sure, ma'am. Sure, ma'am. You can send me.
You can just check, I have WhatsApp that presentation.
Yes, ma'am. I have forwarded to our coordinator.
Okay, meanwhile,
Yeah, you
by
can
the
start with
time,
the.
yeah, I can start with it. So, as you know, my topic is IPR and cyberspace. And I have come to know from Mr. Barua that you all have a lot of knowledge of IPR. And this being the last lecture, I was told to focus more on cyberspace than IPR. So that's very nice because I want that I can interact with you only if you have the knowledge of that very law. So first of all, when the new term which is coming for you is that is a cyberspace. Now, when we talk about cyberspace, legally, if you say it has not been defined anywhere, and you will find that this term has been derived from two words, that is cybernetics and your space. So cybernetics is basically dealing with your technology and its impact on the societies, and then space word. And this word was first coined by a science fiction author, that is William Gibson, and in his book known as Neuromancer. And because we all interact on cyberspace, and we through internet, through computer networks, all these networks are joined together. And when these networks are joined, and the space in which we interact, we have a feeling somewhere in one mind that we're interacting with each other in some space, but it's not a real space as such. In real space, you have computers and wires all connected together, but we can say this is a virtual space where you are interacting, like when it is an online platform or social media, or when you're using the cloud services, or even the lecture which I am delivering. It's not that I'm communicating somewhere. I'm sitting here and you are on the other side of the India, I must say. So it's a virtual space through which we are trying to interact. So this cyberspace has no boundaries, and this also has impact because with a click you can send the information anywhere. When we talk about IPR you have already read that TRIPS agreement which is there, which protects the IP laws. There are 7 types of IPs which the TRIPS is protecting, which you have already gone through various sessions. And I will be focusing with respect to cyberspace regarding your copyright and your trademark law. So how it affects trademark and the copyright. So let me, if you can move further, let me just tell them what areas I am covering in the slide 3. Can I move myself?
Ma'am, you won't be able to move yourself, but you will have to give the direction.
So you will have to go to slide 3 now. Now, this is something which I am going to discuss, a conflict between the trademarks and domain names. And I have just given an idea that what will be my focus. One is what is the functional aspect of the domain names and trademark, and the unique quality of the domain name, the types of disputes which may occur. And also when I told you that it is a borderless situation, the jurisdiction aspect becomes very important, because maybe a person is not here but outside India and not within the jurisdiction. So how can you gain personal jurisdiction over that person? So we have next slide, please? Can we have next slide, slide number 4? Please move the slide. Yeah. Now, copyright aspects will be covering, I mean, focus area will be what will be the subject matter in cyberspace, then how the infringement is taking place on cyberspace, and what will be the fair uses on that, and regarding your ownership assignment and licensing aspects. So can we have the next slide? Please, next slide. Can we move? Yeah. Now, the very first aspect then comes that what is a domain name? Now, all of you access internet through the web address, maybe Rediff, maybe Yahoo, maybe Naukri.com. Now, this is an IP address, you can say. In numerical form, it is an IP address, and this is an alphanumerical equivalent. So, Yahoo, you may have a numerical IP address, and Yahoo is the domain name, which is a second level domain name. The top level domain name can be your com or maybe co.in. These are the top level, second level, and this will become the third level domain. So if it is ccld, .in will be cc country code domain names. So now, so you can say that this is an IP address and how it is related to trademark. I'm just accessing the website, that's all. But it has a lot of relation with that. Now, you know, the very first case which came up on the domain name was Yahoo case. And somebody has registered domain name Yahoo India, because now you have Yahoo India, Yahoo France. At that time, this is 1999 judgment of Delhi High Court. Now, so Yahoo India, somebody registered and Yahoo filed a case that this is my domain name. It is similar to my domain name. So the court had no remedy at that time because this was not a registered mark. It was just a domain name. So how to resolve that? You might have read that in trademarks, you have two kinds of remedies that you may go through an infringement action, if it is a statutory, which is a statutory protection, if your mark is registered, and there is a tortious remedy, that is the common law remedy of passing off. And I hope you know what is passing off. Then the courts thought that how to protect it, because it looks similar, and when you try to access it, I know the services which it is offering is through Yahoo. So courts, that is matters, they started coming to the high courts. They started protecting these domain names through passing of action, saying that these are, since there is no protection under the trademark law, so we will give the common law protection to that. And this Yahoo India was transferred to the Yahoo. Next slide, please. Can you just move this slide? Yes. Now the question is, so many high court decisions came up, like Bombay High Court and various other high courts. They started protecting them. In Bombay, the next case was regarding the Rediff.com. So Rediff is REDIFF, and the other person who registered the domain name was RADIFF. So there was a difference of E and A. So naturally, they filed the case, and through passing of action, the court started protecting them. Now, so there was different decisions of High Court, and this till 2004, there was no intervention of the Supreme Court, but the one matter went to Supreme Court. That is in Satyam Infoway Limited versus Cefinet Solutions. This was a 2004 decision, and there the question arose because the defendant used to say that this is an internet address, and the plaintiff is saying that this is acting as my trademark. So the matter had to be settled. So they said in the very first question in this case was that is domain name entitled to same protection as trademark or not? So Supreme Court looked into the various decisions of the high courts, and they said that when you use the domain name, when I type a keyword, I want to find out a website of somebody, I use the trademark like Tata or Yahoo or Rediff. So it is acting, when you start using it, it is acting as a business identifier on the internet. So when it is identifying the services of Yahoo on the internet, and that is also the function of trademark. And so it starts functioning like a trademark, though initially its function is of internet address, but by use, it identifies the services of the Yahoo or the Rediff on the internet. So therefore, it starts functioning like a trademark, and the way trademark is protected, it has to be protected in the same manner. Even though we don't have an explicit registration in India with respect to domain name, but they should be protected through passing off action. I hope passing off is somewhere where I am passing off my services as your services. So I'm misrepresenting and trying to take the advantage of the goodwill of the other person. So this is how the court started protecting the, now after that, every case which came up, they had been protecting it because the law was settled in the Supreme Court in Satyam Infoway versus Cefinet solution that it is entitled to equal protection as trademark. And in this case, the trademark which was in the domain name which was involved was, one was Cifi, that was the plaintiff, and the defendant, he was SIFFY, Cifi.net. When we talk about the business which they were doing, because Cifi was into the, what was internet service provider, and Cifi, FFI, it was looking into the similar kind of business like, intranet, extranet solutions, all relating to internet and the other facilities, all these software, etc. So the same kind of argument was there that this is a address, and they said this is a Cifi is their own coin word, but they were unable to prove in the court that this is their own coin word and this is a bona fide use of the word Cifi, and they have not tried to take the advantage of the goodwill of the Satyam Cifi. But the Satyam was, on the other hand, was able to prove its goodwill through evidence. So can we move on the next slide? Please move on the next slide. Now, in this very case, the court also tried to differentiate between the trademark and the domain. Now, if you all have read, the trademark law is territorial in nature. All right. And suppose somebody is using in Bombay or Delhi similar kind of a trademark or same identical trademark with territorial restrictions, you can have multiple registrations of the trademark. Now, as regards the domain name is concerned, since your website is accessible globally, there is a universal connectivity, it has to be unique. So it requires worldwide exclusivity. And what happened that since it requires worldwide exclusivity, national laws were not adequate to protect the domain name, and international mechanism not developed. And this international mechanism was in the name of ICAAN policy, which gave a uniform domain name dispute resolution policy, whereby any confusing domain name has been used, the trade through its administrative panel can transfer on making the complaint, transfer or cancel the domain name who has registered in bad faith. So this was the mechanism which was developed, but it did not affect the person's accessibility to the courts. So you could approach the court for your, because the remedy which was available was just transfer or cancellation. You could not get any damages. So naturally, you had to approach the courts for the passing of action. Can we have the next slide, please? Please move the slide. I think there was one more slide in between. One before that, another slide was there. Yeah, next, okay. So I hope under the passing of action, the Satyam case, they had protected the domain name CIFI. Now, basically, when we see what kind of conflicts that arise between the domain name and the trademarks, there can be violation of rights between the trademark owner and the domain name owner, or there can be a dispute between the domain name owner or the domain name owners inter se. These are the two kinds of disputes which are possible. And there is another issue which is coming up as regards this IP is concerned, or trademark, copyright, etc. That is the jurisdiction issue. And because how to resolve this, because there is no boundary at all. So how to resolve that? Can we have the next slide? So this is how, we are giving the protection. I have given you codes. Then under the Trademarks Act, if your trademark is registered, you can go for an infringement action. You can protect the well-known marks also under the trademark law. And then you have the UNDRP policy. And for dot-in resolutions, you have INDRP policy, where you can get your complaints being made. Can we move further? Please, next slide. So the very first thing is, there are people who are using well-known or reputed marks as domain name. Okay. Now, how to give protection? We have under trademark law, because when you use it, this can lead to dilution of trademark. And dilution concept as such is not there in trademark law, but under infringement, section 29(4) is there, which is somewhat a species of dilution. So I hope you all know dilution, where, when you use a trademark for different kinds of goods or services, it may create a mental linkage in the mind of a person that it is coming from a proprietor of the trademark. And what happens that it affects the trademark in two ways. One is that it may tarnish the trademark, or it may blur the trademark. That is what is the dilution concept. So what is happening in 29(4), that is, if you are taking unfair advantage of that, or it is detrimental to the distinctive character or repute of the trademark having reputation in India. So one is that you are trying to take unfair advantage, or it is detrimental to distinctive character, means it is blurring, which is causing of the trademark, and also it is affecting the repute. So that means tarnishment of the trademark. So this is somewhere a species of dilution, which you can say. And the mark should have reputation in India, and you may use it on similar or identical registered trademark if you are using it, even if on the goods or services which are not similar, still that is more dilution is more appropriately used for that purpose. Can we have the next slide? So some of the cases I have mentioned here, where the identical similar domain name have been used to dilute well-known trademarks, and this is you all know Citibank, Citigroup, and the mark which was used here was citicorpbiz.com for financial services, taxation, and insurance by the defendant. So the Delhi High Court had protected Citigroup's trademark in this case. And then another case I have mentioned here, ICICI Bank versus Cheongdong Zoo. Again, this is a Delhi High Court judgment where the trademark, your domain of domain name of and the trademark of ICIC Group, and they had to protect because this person has registered the domain name icicigroup.com for not using for the banking activities. Now, then another case was Supercassette versus Vanzi. Now, this supercassette.com was registered for, pornographic images. So you all know Supercassette, T-series cassettes and all. So they had filed the case. And then this is again, when you talk about using for pornographic sites, dilution is sense of tarnishment of the trademark. Tarnishment means it is affecting the repute of the trademark. So another case which I have mentioned here is the Bedford AG versus Ajay Sukhmani. Now you all know Nivea. Everybody use Nivea cream, and it's an international brand. So somebody is raising the hand. Yes, please. Somebody has raised the hand. Priyanka.
Yes, participants, I request you to keep your questions for the end of the session. Thank you. Ma'am, we'll take up them at the end.
Okay.
Or if you want, we can take up now.
No, if they want to ask something, they can. There's no
Priyanka
problem.
Kumari, if you have any questions, please unmute yourself and ask the question. Priyanka Kumari, if you have any questions, please unmute yourself and ask the question. Ma'am, I think it may have been done by mistake. We can move ahead, ma'am. Yes, ma'am.
Okay, thank you. So this I'm discussing about this NiveaInternational.com was registered for educational services. It's not for the similar types of goods or services. Nivea is separate, but then it is a well-known mark, and it was again protected by the Delhi High Court. Can we have the next slide? Now, the another aspect of the conflict between the trademarks and domain name is cyber squatting. Now, in cyber squatting, what is happening that there are certain people who register the domain name, and then after once they register and they don't use it, and their intention is that they should sell them either to the competitor or to the same person at premium. Okay, so that is the intent, is to sell at premium. And somewhere, even the URDP says that this is one of the bad faith registration, and they can transfer or cancel the domain name on that basis. So the courts also receive such kind of cases, and one of the case is your Aqua Minerals versus Pramod Barse. Now, when we talk about Aqua Minerals is selling. Can anybody say Aqua Minerals deals with what? I've already mentioned here, that is Bisleri. Yes. So it is Bisleri, and he had registered, Pramod Barse, he had registered Bisleri.com, and he demanded, yes, very nice bottle brand, demanded a large sum of money to transfer this domain name. So the court again had to see how to protect these cases. They could protect only through the trademark dilution or the passing of action, and the trademark Bisleri.com was transferred to Aqua Minerals. Similarly, this is another case of Kerala High Court Pen Books versus Padmaraj, where penbooks.com was used to sell it at a premium. Another case which I have mentioned is of Rembexy Laboratories, where Rembexy.eu was registered in Poland. So, and again, the sale was for the consideration more than its cost, and plaintiff had the legitimate interest in protecting its trademark, so it was transferred to the Rembexy. Can we have the next slide? So this is another case which I'm mentioning here. That is, her plaintiff is a Coke studio, and they are having this television series of live musical performances in Pakistan since 2008, and the defendant has registered this Coke studio in 2010. Now he was not using it. 2011 plaintiff wanted to come to India. So they wanted to start similar musical services here. Now, what happened that they saw that this domain name is already registered. So they filed the case in Delhi High Court, and the court said that this was a bad faith registration, and and the domain name was transferred to this person. Can we have another slide, please? Now, there's another concept. So I told you cyber squatting, where well-known marks are being registered, but here this is reverse domain name hijacking. Yani, the trademark holders who are well-known trademark holders, reputed marks, they want to hijack this domain names from the bona fide registrants. So these are the WIPO cases which I have referred to. This is Nestle versus Profit issue, that is Maggie.com. Now, Maggie, all of you know what it is. It is sold by Nestle, but this person, he had registered Maggie as a domain name because it was the name of the chairman, that is Romeo Maggie, and that was his family name. So this was a bona fide use of the domain name. And in another case, Maruti Udyog versus Telrao. So Maruti complained, and the Maruti word was used as a family name, and this is how it was registered as domain name. So they wanted to these are the big companies, they wanted to hijack back these trademarks, but the WIPO did not allow, saying that this is the bona fide use of the marks. Then another very important aspect which is coming up, and a lot of disputes are coming, where these internet intermediaries, and I will just tell you a bit about intermediary. That's intermediary is something like Flipkart or and let's say your Amazon or Google. These are all intermediaries, and they are when you do some searches on the Google or any other search engine, you get certain search results. So in search results, maybe some people want to advertise, and for advertising, they have to purchase the keywords from the Google or the other search engines, and they sell it. They bid the keywords, and this could be the keywords because they say that this is an automatic process. So any keyword can be selected on the basis of the how much it has been hits have been triggered. So the more the these people have searched this name or the word or the keyword, accordingly as per their policy, they will bid it. Now, and those who will purchase, their sponsored links will be you can see on the search results. Within the search result, you will find, and it will be written that sponsored links or ads. Now, this is a very reputed case, that is Bharat Matrimony case, where there are other matrimonial sites like Shadi.com, Jeevansathi.com, and one or two more are there. And these cases have been filed by Bharat Matrimony against them. The consumer is actually Bharat Matrimony. So he filed not only against them, but also the search engine, that is Google. And this is a Madras TV judgment. And what happened that since IT Act Section 79 exempts intermediary from the third party content, third party hosting of any content, any liability with respect to that. So they are not liable provided under the section 79 they fulfill the conditions relating to that. So like, if they have not, if so long they are using for temporarily they are storing for forward communication or hosting it, uh, they they are absolved and they are not modifying it, they are not selecting the receiver. So these are the various conditions which are there, or they are following due diligence, and then if they are not involved themselves in the unlawful activity, or if, and secondly, if they have been informed about it, they have been given knowledge that this activity is happening and they have failed to remove it expeditiously, in that case they may be liable. So every intermediary tries to take the benefit of the section 79, no matter how much active involvement is there, saying that I'm an intermediary and I'm absolved from any third party liability. So the same thing happened here. This Bijoy has raised the hand. Yes. In the next slide, I have just given you that they give the offer, they give you the keyword, suggestion tools are there based on how much you can bid. Maximum bid has to be selected by you. And so the Google was also, complaint was against the Google also. So Google said that I am an intermediary, my process is totally automatic, and I have no knowledge that these people are using trademarks of someone as keywords. Now, so what happened? The court ruled in favor of Google, and they also ruled in favor of defendants in some way, because the marks which were there, like they're writing Punjabi matrimony, that was of the bharatmatrimony.com. So Punjabi space matrimony, it was not together. So somewhere, this is a benefit of doubt you are getting, that you are using the common words in the vocabulary, Punjabi, matrimony, which everybody has a right to use. So that's why they said that they may be the the competitors, but somewhere they are not using together. That is space. But what happened when in Supreme Court, when they went to the Supreme Court, they restrained the respondents, that the Shadi.com or the Jeevansati.com, from using the keywords of the bharatmatri.com. But Google was absolved. They said Google is not liable. Google has no knowledge. Unless and until he has actual knowledge of the fact, he cannot be made liable. Now let's move to the next slide. Next slide, please. Please move the slide. So I told you this was an earlier case. Now recently, the trend has changed. You saw that the Google was absolved under Section 79 regarding the liability of the intermediate for the persons who have used these keywords for trademarks as keywords. In Google versus DRS Logistics, which is a recent case decided in August 2023. I must not say recent because now it's 25, but the trend has started now in the similar manner. So this is again of Delhi High Court. Here, this is, you might be knowing about the Agarwal movers and packers. So that is a trademark for the services which they are offering. I hope you know the services which they offer. movers and packers is itself clear that they are doing that kind of an activity. And their trademark was used as a keyword by the competitors. And Google has, as I told you, Google is selling these keywords. It has a policy based on how many hits are there. I access the search engine with a word or a keyword and to search. So that keyword is used how many times? Depending on that, the bid was there. So this is how they had been. They all bid it, and they also show you that if you bid for this one, this will be the bid. So you select the maximum bid. And what happens then? A keyword which has been used most of the times, and that has been selected. So your link will come at the top in the Google search results. So the sponsor links, their competitors, the links were coming at the top, and that's what the DRS Logistics filed the case, that this is the use is against the Google, basically. They filed a case against Google saying that Google is equally responsible. So what is Google is doing? They are selling keywords to advertisers. Somewhere you're using it in the advertising. And you have a complete control. Suppose, there are a number of persons who have used the same keywords. So you have to select who will come at what position in the search result. And you have a complete policy regarding that. You have a complete control of it. And it is you who display the ads where the position will be there. So complete control being used in the advertising. How can you say that you don't have the knowledge? How can you say that you are not using it in advertising? Can we have the next slide? So the court says it's difficult to accept that the Google is entitled to exemption under Section 79 of the Act. So he says Google is not a passive intermediary. Like he said, 79, if you are just temporarily storing or for forward transmission or just hosting the content, that you are not liable, but your role is where you have a complete control. You are not a passive intermediary. You are running an advertisement business where you have a pervasive control. So they said this is a prima facie case which was decided, and they said that the trademarks, when they are using trademarks as keywords, does amount to use in advertising under the TM Act, and this is a use in commerce under Section 29, subsection 6 D of the Act. So you could see, and trade, because in the earlier case, Google was absolved from the liability. It did not bother to see that we should not offer the trademarks as keywords. So they were simply offering each and every word. But contrary, the situation outside India was different, where Google was controlling. And here, so from here you could see there is a change in law. From where the Google was absolved, and now they are saying, the courts are saying, no, you are using and you will be also held liable for that. But this was a prima facie case, because when the case goes further on the evidence level, at the trial level, then only on the basis of evidence you can decide whether you have a control and you are using it in the advertising. So prima facie court found that Google is using in advertising. So can we move to the next slide? So another type of disputes which I discussed with you is your identical or phonetically similar domain names. Within the domain name holders, you have the dispute, and this is also known as typo squatting. Now, what happens? May I have the earlier slide, please? Yeah. So you could see I have mentioned number of cases which has taken place. One is the Rediff.com case, which of the Bombay High Court, where you will see the difference is RE and RA. Then Naukri.com case, where you will see the difference of A. This is Naukri, ARI is jobsourceindia.com. So what were they doing? They were using the domain name Naukri.com, and all the traffic was diverted to jobsourceindia.com. So all the traffic of Naukri.com got diverted to jobsourceindia.com. So this is how they were using their domain name. Again, the domain name, the court gave the relief in this case. The other cases which I have mentioned here is tehelka.com. Tehelka, you will see the difference in TE and TA. Again, you have yahoo.com/treble, yahootourism.com/treble, and then Microsoft.com and MicrosoftFundIndia.com. Okay, so you could see this. Can you just give me a
Ma'am took a small break, that's why it's not audible.
sorry for a minute. So can we have the next slide?
Ma'am, if you want, because it is a very long session, if you want, you can take another short break, like 10-15 minutes in between, whenever you feel like. Ma'am, please unmute yourself, ma'am. Ma'am, please unmute yourself, ma'am.
After finishing trademark, we can have 5 minutes rest, and then can we move on to the next slide? So this is another, the case, MishoGift.in. And this is Fashionir Technologies versus Misho Online. And it is a Delhi High Court decision of 2022 in this dispute between the both cases. MishoGift.in, which was registered. You all know Misho is a well-known website. Then the other things which are there is generic or descriptive words. This is Malar TV case. It's of Madras High Court, and Malar is used for magazine. So Malar TV, when you use in combination, that was allowed, and the person here registered malartv.in. So they said you can use some other, the domain name, but not use Malar as such. But these are generic or descriptive words. Then this GoDelhi.net and GoDelhi.net dot uh, go Delhi tours. So you could see there is a generic names which has been used. These are the generic words which we use in our daily uh, life. And but in these cases, injunctions were not granted. But if you see in Mutual Fund India and Mutual Funds India, contest to win or bid to win, we could get the injunctions because they were totally similar and very common words which we are using in our common language. Can we have the next slide, please? There is another aspect of I think Bharat Matrimony we have discussed. Can we move further? Uh, Again, here. Just leave it here. So I just, in continuation with Bharat Matrimony case, and then this one where the platforms, e-marketplaces, they are selling the counterfeited goods online on marketplaces. You visit Amazon, you visit Snapdeal, and you make so many purchases from there. And what happens here is that these online markets, there's a seller and a buyer, there is an intermediary in between. So it acts as a bridge. So Flipkart, Google, Snapdeal. So you could find some counterfeited goods being sold there, and where the identity of the seller is being hidden. Can we have the next slide to give them some idea about the various cases? Now, this is something I have tried to explain because earlier also, while dealing with the Bharat Matrimony case, I told you that how intermediary functions. So I have just showed you that under section 79, it has a passive role as a facilitator where you could access or you could there could be temporary storing or hosting for further transmission. Now, can we have the next slide, please? And what intermediary can do is it cannot conspire, aid, or abet the unlawful act, and it cannot initiate transmission, it cannot modify transmission, or it cannot select the receiver of transmission. This is under various subsections of this section 79. Can we have the next slide? Next slide, please. And what it has to do, I used the word due diligence earlier. So due diligence has been explained in the rules. So now we have Digital Ethics 2021 rules regarding of the intermediaries, where they have explained due diligence with respect to the social media intermediary and significant social media intermediaries, where the users are more like Facebook and others. There they have additional due diligences also. So the due diligence here, I must say that you have your own regulation, you have your own policy, privy policy, and you should inform the users and, that they are not supposed to violate the IP of someone. So these are all due diligences. And various other clauses are there. And so they have to follow due diligence. And secondly, you have to remove the unlawful information which is there. So either on the court order, or if knowledge is coming from the affected party, or from the government notification. So you have to remove it expeditiously. So this is all section 79, which I'm explaining. Can we move further? Now, these are the cases relating to the online marketplaces. One is your Kent RO versus Amit Kotak. Now, this is a case where on eBay, the design of the Kent, Kent, that is your water filter, design of the Kent was copied, and the plaintiff wanted that eBay should be restrained from hosting such products in future also. So if to eBay, you give the acknowledge that this is happening, because eBay doesn't know who is hosting what product there. They don't make any inquiry with respect to that. And their role remains passive. So therefore, they said we will remove it if we have the actual knowledge. So actual knowledge can come from court order, as I said, or it can be from government notifications, etc. And the party may inform that this is what is happening. Now, as regards the future products are concerned, the court said that intermediary cannot act as a judge for screening the content. Kya content hai, what content is there and what is not there. Then another very important case, that is the Christian Logolbe versus Nakul Bajaj, where the seller's identity was hidden, and this person whose site was there, they had used own packagings, and so they said that you were actively involved in selling the counterfeit products. However, this case also, what I'm mentioning is a single bench and division bench. On the procedural grounds, the injunction was removed. But if we see, but single judge has touched on these areas, maybe on the facts or the evidence, which the division bench felt that they cannot, injunct. But the law remains the same. Similarly, Titan versus Snapdeal. 2009, Titan gave the notice to Snapdeal to remove the counterfeit fast-track watches. Before that, fast-track watches from their side. They did not do it. So the Titan had to file the case against the Snapdeal to get the court order to get these fast-track watches removed from their website. So then only it was removed. Then I have already mentioned about the other cases with Consim case, and then MySpace case, which is again, regarding the intermediary liability with respect to the copyright also. So that we'll discuss later on. Let me move on to the next slide. Now, as I told you, just happened in case of Google. Now, these people, the Amazon, they are the massive facilitators. They provide you listing, they provide you warehousing, transportation, delivery, return, refund, grievances also. They're giving you a lot of, you can give services. There's no harm in that. But you see the control of the Amazon. And on that control which they have, they said, we don't know what product this third person is hosting on their website. We don't know. We are just the intermediaries. We are just providing you the facilities. And you have fulfilled by Amazon. How can you say that there is no control and they don't have knowledge? However, can we move on to the next slide? Now, this is a case MBA versus 1MG. You could see this MBA, Modi Care, Oriflame, they are sending, there is a direct selling entities. You cannot sell them in the market or on e-commerce platforms. These are the requirements of these direct selling entities. Now, they could find the Modi Care, MBA, they could find their products being sold on e-commerce sites like MBA. And so they filed the case against these intermediaries, and the court had to look into the aspect of trademark violations, whether there was trademark violations or not, or whether they can have the protection of Section 79 or not. And there was another aspect, inducement of breach of contract, which these platforms were doing. Now, can we move to the next slide? So the single judge basically, after looking into the evidence for prima facie injuncting them, they said that this use is unconsented, and then you have a display of image in print, and then they also said that the seller's identities are hidden, source is not clear, warranties, refund, return. And when the local commission reviewed there, they could see that even the codes, unique codes were removed, and that could lead to tarnishment of the product of the plaintiff. So this is detrimental to distinctive character, and they are using it as a trademark on the platform. Can we have the next slide? Can you move this slide? Yes. So they also took the defense was of exhaustion. You know, Section 30. Once the product has been sold, in second sale, the rights are exhausted of the trademark holder. So, but there are conditions, that there should not be an impairment of the goods. Goods are lawfully acquired and all these under the Section 30. So they said you are changing the packaging, you were changing the unique codes, your seller identities were hidden. So somewhere, the court felt that the exhaustion principle will not be applicable. Can we move next? And again, as far as the intermediary exception is concerned, they said you are a massive facilitator. You are not a passive person. You are actively involved in that. You are actively involved in selling this counterfeit products, and you're not following even your own policies regarding the due diligence, and you have a prohibited product seller list which you are not following, and you have been given notice, you have actual knowledge. So prima facie, you're not entitled to safe harbors. But unfortunately, in the division bench, on certain procedural grounds, saying that the plaintiff did not raise the trademark issue in this case, and various other things. And as regards the intermediary exemption, they said you can only come to know through trial and evidence. You cannot say just by the visit of the local commissioner that there was impairment or because they could say that there is only one case where the impairment was there. So the injunction was removed, which was granted by the single judge. Now let me move further. So that went in favor of the Amazon and all, and against the MBA and the direct selling entities. Can we have the next slide, please? Can you move the slide, please? This is another aspect of tortious interference and inducement of breach of contract. Like as an e-commerce platform, there's a contract between the two parties that you cannot sell. This is, on the e-commerce platform, but you are inducing them to sell. So this is tortious interference and inducement of breach of contract. There's a contract where you are inducing to breach. And this is, one of the parties then break the contract. So this is third party commits actionable interference with the contract. So then what is this torsion interference and inducement of breach? So they said they should adhere to policies. They should insist sellers to bring consent letter, and they want plaintiffs to prove that products are they should be genuine. And then distributors can sell in gray market. This is the problem. And continued sale, if you allow continued sale, then what will happen? This will result in inducement of breach of contract. So this is a public policy, basically, inducements of breach of contract, that there are a contract between two parties and you somewhere induce by allowing them to sell them. You don't know because seller's identity is hidden that these are actually second sales, or whether, it's the original product or something else. You can't come to know with this aspect. So this is one aspect, but court had dealt it. Can we move to the other slide? So what we have seen that the single bench has certainly looked into the aspect of passive and active role, and depending on that, he has made liable the intermediaries here. Can we move further? This is, I'm saying the DB decision was reversed on certain grounds. Now, another aspect which we need to look into is the jurisdiction. As I told you, there is no boundaries, and which court will have jurisdiction. As website can be accessed from anywhere, right? So then there is a problem how to exercise the jurisdiction over non-resident defendant. And there is absence of long arm statute. You need to have an extraterritorial jurisdiction. Now, what happens? Jurisdiction. If you see, there is one aspect of private international law which comes into picture. Private international rules will be applicable when there is a foreign element involved. And in these cases, if a defendant is outside India, there is a foreign involvement of foreign element. So we need to go through first the rules of private international law and then find out what is the law on the basis of which we can exercise jurisdiction. And these rules of private international law are different for every country. And that is also known as conflict of laws situation. Now, what happens that we in India, we have a rule that how to find out the jurisdiction if a foreign element is involved. That is, you have to look into lex fori, that is, procedural or law of the place where the dispute has arisen. So what is the procedural law of the space and place is when you talk about India and we talk about the civil case, it is a civil procedure code. So how we are going to exercise jurisdiction on the basis, first we move to the rule of private international law and then to CPC. And under CPC, you all know what, the rules relating to jurisdiction where defendant resides or where carries on business or works for gain, or if defendant is not residing, then we have section 20C where cause of action wholly or partly arises. So most of the trademark cases, either you can go under the CPC, or if it is a registered trademark, there is an additional place which you can file the cases where the plaintiff carries on business. Can we move on to the next slide? Now, the early cases in India regarding the jurisdiction, this I'm talking about 2003, because I'll just tell you the development of law and jurisdiction, how it took place from 2003 till date. So the first case which came up on the cause of action, that is Casio India Limited versus Ashita Telesystem. Now, naturally, it's a domain name case. You on a trademark, somebody has registered domain name as Casio, and they said you are passing off my goods as your goods as my goods. Now, what happened? The question of jurisdiction came because defendant was operating through website, and its website was accessible everywhere. As you know, a domain name through domain name, you can access your website from any place. So this website was accessible everywhere. Now, court says wherever the website is accessible. So it is, I'm sitting in Bombay, Delhi, anywhere. Now, how the Delhi court assumes the jurisdiction? If you are sitting in Bombay, you're sitting in Madras, you're sitting anywhere, the website is accessible. So the defendant, the plaintiff can go anywhere. I can go to Madras. Your plaintiff, your defendant may be in Bombay or Delhi or maybe somewhere in Jammu, and then you exercise jurisdiction in Delhi High Court or Madras High Court. So that jurisdiction may not be, convenient. It may not be convenient to the defendant. It can be a forum non-convenience. But the court said here, from wherever the website is accessible, you are using the trademark, and cause of action, passing off is taking place there. Cause of action is arising and passing of action is possible, is taking place. So this is the early judgments which happened in India. This next judgment came in 2007, that is India Independent News Services uh, uh, case. This is actually IndiaTV.com who filed the case against IndiaTVLive.com, where you had filed the, they had launched the similar kind of channel from India and Los Angeles both. Whatever the news channel, IndiaTV.com. So similar kind of activities were there. They said, we are in the Los Angeles, the Delhi court has no jurisdiction, but somewhere cause of action is arising here because the plaintiff is in India and passing off is taking place here. And you are in India, there are sufficient contacts with India because you launched it from India as well as Los Angeles. So there is a sufficient contact with India. And therefore, the cause of action is arising because of your activities in India. And therefore, the test which they had applied here was that whether defendants' activities are having sufficient connection with forum, whether cause of action has arisen here because of defendant activity, and whether the exercise of jurisdiction is reasonable or not. This is basically a purposeful availment test as laid down in the US cases. So they said that defendant is targeting India. These aspects were not taken in the Casio case. Casio case only said that websites accessibility. Accessibility means there is passing off. But this is not in India TV. They are looking at whether he's targeting that very, the forum or not. So he says plaintiff's news channel is for the Indian ordinance and the damage will be suffered in India itself by the plaintiff. And the users can also subscribe to its site. Site is an interactive site. So even this aspect was taken into consideration that users can subscribe. And so the court said the Delhi court has jurisdiction. So defendants are carrying out activities within that. So that means they're doing business here. And that's why the cause of action is arising. And they did not look into the business part in Casio case. So here the change in law is coming. And the claim is because of the consequences of the activities of defendant within the jurisdiction. Can we move on to the next slide? This is a very important case which laid down the law which is still followed. That is Banyan Tree Holdings versus Murali Krishnan Reddy in Delhi Division Bench. This is a judgment of Justice Muralidhar, who is retired now. In this very case, Banyan Tree was banyantree.com/spa. Banyan Tree was a spa which is, which they collaborate with the Oberoi hotels and they are offering these spas, and the device of Banyan Tree and the Banyan Tree trademark which they use. And here the defendant has used the banyantree.com domain name. So naturally the question came up because the defendant, both plaintiff and defendant, they were not residing within the territory of India, and one was in Singapore and another was here. Court, firstly, the very important thing which they held was that Casio case was overruled in Banyan Tree. So no more exercise of jurisdiction on the basis of accessibility of site. So Casio totally overruled. As regards the India TV case, they said that the finer aspects relating to the jurisdiction have not been discussed in India TV. Though they are nearing that because they're talking about purposeful fulfillment, that is businesses, activities have been taken place here. So what is the nature of activity a person is performing? Suppose it's a nature is relates to the business of immovable property. Naturally, I cannot do business at some other place where the immovable property is situated. I'll be doing business there. So nature of activity becomes very important. Even if some brochure or something has gone in some other jurisdiction, that doesn't mean that I will be able to do business there. So I cannot conduct business activities there, and how can cause of action arise? So nature of activity becomes very important, whether it will result in commercial transaction or not. So we need to see whether some business activity, are you targeting that place? So you will come to know by targeting means, suppose, what is the language of the standard form contract you have used, or maybe what currency you are using. All those things gives you the evidence that whether you're targeting that place or not. Then the evidence from where you will come, he says whether the plaintiff can use a solitary trap transaction to say that he's targeting this jurisdiction. The court said no. Said there has to be real commercial transaction. Even if you are putting a series of trap transactions, you have to show that these have been obtained by fair means. Okay? And plaintiff has to ever unambiguously in the plain that and has to give us supporting material to prima facie show that trap transactions relied they were the true, the trap transactions. So it has to satisfy all the tests. Then only you can say he is conducting business here. So thing is that you are how the cause of action will arise here. You are targeting this place, and the injury which has been caused to the plaintiff, it should result because of his activities within the jurisdiction. So the American test of your purposeful availment and the effect test, they are all discussed in detail in this case. Then only the court arrived at this decision. They were combined. And then they said that the cause of action will arise here. Not simply on the basis of your accessibility of website or purposeful availment, like you have an interactive site or a passive site, or you have a integral site. That was not sufficient. You need to see the effect also. Firstly, you see whether you are targeting, and then injury has been resolved because of activity. So effect is also coming here. Then only the court can say that cause of action has arisen here. Can we have the next slide, please? Now then we have, this is again a Prestige property versus 2009 case where, the business was of building construction in another jurisdiction. That was not possible within the, at some other place. So the court does not have the jurisdiction. That's what they said. Can we have next slide, please? The other aspect, now we have seen about the cause of action. Now, even the trademark cases, they can file under section 134(2) where plaintiff carries on business. Now, this is again a very, the banyan tree settled certain thing, but then ambiguity arose as regards to where plaintiff carries on business online, that is through website, or maybe through when you are interacting through emails. And so this is a case like World Wrestling Entertainment versus Reshma Collection. This came after the Banyan Tree case. And they had two World Wrestling talents are there, which have been used by the defendant on their products. And they sold those products using those talents. So plaintiff is in US and defendants are in Mumbai. May I have the next slide, please? Now, how Delhi High Court assumed jurisdiction in this case? So the word is, plaintiff carries on business. And this can be somewhat similar to CPC where defendant carries on business. So meaning of carries on business can be taken from the judgments which explain what is carries on business. All right. So one of the case where it was, the law was laid down with respect was Doda House case, where though the website was not involved, but what is carries on business, that was explained. And they said that there are 2-3 essential things which we have to set, right? That there has to be a special agent, and then you have to there should be an agent and the special agent who should work for this plaintiff only in that jurisdiction, and your essential part of the business is taking place there. So if you satisfy all the 3 things, then that means plaintiff is carrying on business. Now, plaintiff need not be present in the jurisdiction, but through his special agent, he is carrying on the business. Now, the court said that in this very case, when you are selling through website, naturally, you don't have any agent. So you cannot look into the first clause or the second clause of special agent. But they said, if you are doing business through a website, then this has been done directly, through, let's say, through website, you have a direct presence. So you can leave those 2 clauses of Doda House. The third clause remains whether the essential part of business is being taking place on. Now the court actually combined here Bhagwan Das Kedia. You all know law relating to contract, Bhagwan Das Kedia, where the contract is concluded. The cause of action arises where the contract is concluded. And the contract is concluded where the communication of acceptance is, where acceptance is communicated, you must say. So the Delhi court, it assumed jurisdiction, saying since he's selling, it compared website like a shop. Just the way you sell on the shop, you are selling through website, and business transactions are taking place in this jurisdiction. Then you can assume the jurisdiction. But this again, created a problem in a sense that, so if the contracts are concluded here, they applied Bhagwan Das Kedia, cause of action is arising, essential part of business is taking place. Now, the problem in this case which arises is that it's not based on like cause of action, like injury to the plaintiff and all, which held in Banyan Tree case. So you become very specific to the jurisdiction. Here again, forum shopping can take place. So contract may be concluded in a number of places, and plaintiff can carry on business there, and you can assume jurisdiction. So this is one of the problem which existed, but then there are other cases which came up, like Victory Entertainment case, where, when there was a corporation, any company is involved, then they said that place will be that place where it has a branch office and a branch of wherever cause of action is arising, and it should have a branch office plus cause of action should arise there. Then only you can assume the jurisdiction, not otherwise. That was also a case relating to the plaintiff carries on business. So can we move on to the next slide, please? I discussed with you initially also while discussing your Satyam Info case that there is a policy at the international level, that is ICAN, dispute resolution policy, where if you make a complaint there, an administrative panel is there. It's all online process, and their rules are there. Rule 4 is important in a sense that it gives you what happens when you can file a complaint, that when you use a domain name which is identical or confusingly similar to the trademark, owner has no right or legitimate interest in the domain name, and it has been registered in bad faith. So these are the things which you have to tell them, and on this basis you can file the complaint. Now, can we have the next slide, please? Now, what is bad faith registration? It is in Rule 4B, which says 4 circumstances have been illustrated. One of them I already told you regarding your cyber squatting. That is, if you have out-of-pocket excess of documented out-of-pocket cost, you are demanding, you are selling into the competitor or transferring or selling, renting on a out-of-pocket cost or to sell at a premium. That is a bad faith registration, and there are other grounds also which have been mentioned, which I have given here. Can we have the next slide, please? And these are the defenses. As when I discussed Maggie case and your Bharati case, the defenses which are available, that is, it's a use is bona fide, you are commonly known by the domain name, or there is a legitimate or non-commercial fair use. These are the bona fide grounds, as you have in Trademark Act also. You have section 12 of the trademark law, honest and concurrent users, their mark can be registered. Can we move further? Again, we have similar to that is we have adopt INDRP, that is not in this the domain name resolution policy in India, and you can make a complaint there. There is an arbitrator who resolve that complaint, and similarly it can be transferred to EU. Now, this is there are certain cases which have come up that what is the effect of the decision of administrative panel on URDP or INDRP on jurisdiction of courts. So when we talk about this Nivea case I discussed earlier, they said that decision is not of the administrative panel is not binding on your courts. You can file a case in the courts. It will not act as a res judicata. I think if you are from the legal side, you understand what is res judicata. The same case with same cause of action, it cannot be, with same issues, you cannot go to the court again. So the first decision acts as res judicata. Res is, dispute, you can say, and judicata already decided. So not binding on courts, and it's not an arbitration award which can enforceable under Arbitration and Conciliation Act. So jurisdiction of civil courts is not barred. This is what they are saying. Can we have the next case? Then this is City Corp case which dealt with the INDRP, but here they said that provisions of the Arbitration and Conciliation Act cannot be invoked unless there is a binding contract or written agreement between the parties. So this is not a new statutory remedy which will bar the jurisdiction of the court. And there is no ouster of jurisdiction of civil courts. But when we look into the next case, can we have the next case? The Stephen Cohen case, they said this under the RDRP, they said this will fall within, you can test it on the light of Section 34 of Arbitration and Conciliation Act. But limited interference will be there, that is based on patent legal errors or contrary to terms of agreement. And if the decision is so unreasonable that no reasonable person could have reached the conclusion. Can we have the next? Yeah, this is again another case, very recent case regarding whether who can approach. They said only who can approach the court under the Section 34. It is the complainant, registrar, and registrant. Any other beneficial party may be there, but he cannot approach the court to challenge the decision of the INDRP. Can we have next slide, please? So these are some of the conclusions which I have given. Domain name is entitled to equal protection. Then we discussed about the jurisdiction, where cause of action arises. And then plaintiff carries on business. Uh, Accessibility of website was not allowed, but you have to conclude the transactions there. In cause of action, you have to see you have targeted there, and the injury has resulted because of the this very act of the plaintiff, activities which are carried on by the plaintiff. And as regards the decision of administrative panel of URDP, it is non-binding. INDRP, you can go for, there can be limited interference of the court. Okay, can we move further? So Indian courts are certainly protecting your domain name holders through passing of action. Cyber squatting, you have common law remedy, but there are certain issues which are unresolved. That is, suppose, I want to register, somebody has same trademarks, you have registered as a trademark, but domain name has to be unique. So how to satisfy all those multiple registrations, bona fide multiple registrations of trademark? That is one of the problem which is still not been solved. Can we have next slide? So can we have now break of 5-10 minutes? How much?
Ma'am, as per your convenience, ma'am.
No,
Usually
whatever way
10
you.
minutes is okay, ma'am.
Okay, fine. Fine.
Yes,
Thank you, sir.
thank you.
Thank you. We'll meet after 10 minutes.
Sure, ma'am. Ma'am, can we start the session, ma'am? Ma'am, can you please unmute yourself? Ma'am,
I had sent message to Mr. Barua whether I can start or not.
oh, yes, ma'am. We can start the session, ma'am.
Fine, thank you so much.
Yes, ma'am.
So we had been discussing in the earlier session about the conflicts between the domain name and trademarks. Now, the other part, other IP, that is copyright, you all have studied in your sessions. Again, in the virtual world, you will see that how the rights have been violated, or what are the problems relating to cyberspace, that new problems which have come up with regarding the copyright, because new works have come up and for which we need protection. As I discussed in the first slide, that my focus will be at what is the subject matter, or originality, and then fair use, and then about the assignments, etc. So that portion I'll be covering. So can we have the next slide, please? This is something I've just given, you all have read it, that what is the law relating to copyright, idea expression, skill capital, what are the various works, like primary works and the secondary works, and just explain what are these works. Can we move next slides, because they have already done it. And these are the works. Again, what I'm saying is that you have 6 kinds of works, but what is not protected here? Now, when you look into the cyberspace, you have various kinds of works. Like suppose a web page. A web page may have a lot of primary works. It's a derivative work. Like you have music, you have written text, and then you have images into that. And they can this forms a multimedia work. So it's not one work which is involved in making the website. Number of works are there. And we have definition for sound recording, we have definition for cinematograph film, we know what are the works. So only 6 works apart from multimedia work which has come up, which is a new kind of work which is there in the webs on the cyberspace. It also needs protection. So so long, there is a lot of ambiguity whether you protect through who and what I want to say here is that who's the author of this work, that also is important, because number of works are involved. Let us move further. Next slide, please. Yeah, then you all, let's come to the subject matter. What is the subject matter here? The previous slide. Now, I have mentioned here, the websites. If suppose subject matter is website, and in a website you have some compilation. So what is the originality in that? So when we say originality, you would have already read that Eastern Book Company case, which talks about the compilations of judgment, and a new law has been developed here, from sweat of the brow to minimal creativity, which has come up in the Eastern Book Company case for the concept of originality. So concerning your websites, so if we see, you have text, images, pictures, and then you have one of the cases, this was a compilation, mortgage market guide case. The web page had certain financial information related to mortgage-based security. So there were comparative, database like bond prices, trend lines, moving averages, and charts, etc. These were all there in public domain, but they compiled it. So compilation here, the facts may be in public domain, so we don't have any copyright on the facts. But then the selection and arrangement which has been done, that is your original creativity in that. So that has to be protected. And the competitor of this MAG had copied the web page, and the court said that they have they have infringed the copyright because they had copied their selection and arrangement. Can we move further? These are the economic rights relating to literary, dramatic, musical. You all have studied reproduction, including storing in electronic form, then communication to public. These are or adaptation, translation, etc. These are the rights with respect to various works. For literary, dramatic, musical works, you'll find separate rights. For computer programs, because computer program is a literary work, so it will include not only these rights, but also your rental rights with this. Can we have the next slide? So as I gave you all the above plus commercial rental rights, then we have artistic works. Again, you have separate rights for that, where you may not have a translation right or performance right in this. Can we have next? These are relating to cinematograph, film, and sound recording to make a photograph, rental rights, and communication to public. Can we have the next slide? Because I don't want to spend time on this, reason being you have already done all this. This section 51 relating to infringement, how infringement takes place. One is there is a direct infringement. You have any act which is given in section 14 we have done without the consent. Second is secondary infringement, which also becomes important because relating to intermediaries in the internet, because somewhere they're providing the web space to upload the things and host certain things. So basically, you are permitting place to be used for communication to the public, and where such communication constitute an infringement unless he is not aware of infringement. Now here, I basically told you section 79 of the IT Act, which give you safe harbors to the intermediaries, which says actual knowledge if they have, then only they'll be, and they have not removed, they will be liable. But here, when you see the copyright law, it says unless he was aware of infringement. So he's not talking about actual knowledge. So when we talk about section 79 and section, the Copyright Act section 51, A2, then in that case, some conflict is occurring, but we have section 81 of the IT Act, which says notwithstanding anything, anywhere, non-obstante clause is there, that IT Act will be applicable. But they made an amendment in 2008 where they inserted a preview saying that it will not be applicable to trademark, copyright and patents. So there how the conflict can arise between these sections, between IT Act and your Copyright Act. And how that was resolved, we'll look into it later on. So this is infringement of copyright. Then this is a test of infringement in the RG Anand versus Deluxe. Means that there is a substantial copying, idea is not copyrightable, facts are not copyrightable. And then the test of the spectator. And if there are broad dissimilarities, then you can say that it negates that there is any copyright infringement. And you need a cogent evidence for that purpose. So can we move next so that we should not repeat whatever is there. Now I'm just taking some of the examples. So we just saw that there are rights which are available to the authors, and these rights are not only getting violated through the real world, but also in the virtual world, and much more in the virtual world. Because when you make a reproduction of the work, when you make a photocopy, you can differentiate between a copy and the original work. But here, when it is an ebook and you make a copy of the ebook, what is going to happen? You cannot differentiate whether it is original or it is a copy. So then copyright law becomes much more important as regards the cyberspace is concerned, and we will see that not only one right at a time is getting violated, simultaneously 2 or 3 rights are getting violated on the internet or cyberspace. Now, some of the examples which I have given here, you might have heard of, Napster or Kaza, where they allow you to share and upload music. So you upload something and then you put it in the share folder. Somebody can download from that. So this can be, let's say, this can be a copyrighted work. It may be a work which is in public domain. But if it is copyrighted, then it's a problem. So Napster was sued because of this, because many of the copyrighted musics were shared. And what was happening, that Napster was having a central server, and you had to communicate through central server. So somewhere, you are providing, I gave you the copyright infringement, permit your place for profit. So you are providing some space. Place can include your web space also. So web space has been provided, or your server has been provided, and you are actually contributing towards the copyright infringement. So since so many cases were filed against the Napster, so he actually had to close down his services as regards to these are also known as P2P sharing, peer-to-peer sharing file networks. So then the further models which came up, like Casa and Grosster, they were not keeping the central servers, so that they should not be made directly liable. These cases continue, and we will discuss later on. So one of the case which we can also look into where rights are violated, and here defendant downloaded 24 songs via Casa. So they were the copyrighted ones, and therefore they were awarded damages to the tune of 1.92 million, and it went against the defendant, the user. But later on, the Copyright Society, they thought they will not file the case against the users. And that was decided as a policy. Can we have the next slide? Now, another case, is there any other slide before this? Yeah, please go to the next slide. Go to the next slide. Now, this is another thing where, I spoke about the direct users, how cases were filed, but this is a case, Indian case, where you have filed a case against the myspace.com, where it allows you, it gives you space to, upload, download music files and all. So the super cassettes, that is the T series, they filed a case against the MySpace. They're saying that they gave a notice that you remove all copyrighted song of ours from your website, and you also, these should not be uploaded. What the super cassette gave to them was their own catalog, which had so many thousands of songs, and they did not say that this is a specific URL which you have to remove. So knowledge was certainly there, but actual knowledge in the form of URL, that this is the specific URL we have to remove, that was not given. And then MySpace did follow due diligence. They informed their users that they cannot violate the intellectual property rights of anyone. And secondly, they also informed, the users that their agreement can be cancelled Yes, please. The agreement can be cancelled. I think I just use the. Can you just give me a disturbance? So now is my voice clear?
Yes, ma'am.
Okay. So what I was saying that MySpace, he had a rights management tool whereby these copyright owners could use that tool and create the fingerprints of those, the URLs, and then on the basis of that fingerprint, you could remove the other URLs also. It is similar to that. But the super cassette did not use that very, let's say, the rights management tool. Rather, they said that since you have the knowledge that the super cassettes, I'm sorry, the this very MySpace has kept the right management tool. That means they have the knowledge that copyright infringement is taking place. So whether this is correct or not. So because in single judge, he gave the decision in favor of super cassette. But in division bench, then MySpace argued certain things, saying that my process is an automatic process. I have no knowledge what they are uploading, and but one of the argument they said you have modified, but they were giving advertising. They were attaching the advertisements, but that was not. They were not looking into the content. What is the content? So there were millions of files which are uploaded or shared. They could not look into the content of each and every file, what has been uploaded. So they said that we are the intermediary and we have exemption under Section 79. So we should be exempted. So
Excuse me, ma'am. Ma'am, I think without that earphones only, your voice is more clear. Oh, okay, ma'am. Oh,
So now is it clear?
yes, ma'am.
So what I was saying that the MySpace said that this process is an automatic. I should not be made liable under for copyright infringement. I have safe harbor under Section 79. Whereas the super cassette said no, the IT Act will not apply because there is a preview to Section 81 which says it will not apply to copyright. Now, so the conflict arose whether 79 will be applicable or not, whether they'll get the exemption or not. So the court had to resolve the conflict between Section 79 of the IT Act relating to exemption of intermediary from the liability, Section 81 of the IT Act, which of the privy of the IT Act, which says the copyright, this will not apply to copyright law, copyright. And then thirdly, the section 51A2, that is permitting the place for profit. And if you are not, unless and until you are not aware. So the word is awareness there. And if you see section 79, it is knowledge. Okay, so actual knowledge, not knowledge, but actual knowledge, or you can say specific knowledge. And in other places, it is, in the other place, it is general awareness. So what was the law followed internationally? It's, basically they, in internet cases, they look into the specific knowledge. And our law also says that it is specific knowledge, not the general awareness. But copyright law says general awareness. The court had to interpret the three sections together. So they said when section 79 was amended, 81 was also amended at the same year. And there was no provision in section 79 which says that it will not apply to copyright. So when we talk about the internet cases, the cases relating to cyberspace, we have to interpret, in case of intermediaries, not journal awareness, but it has to be specific knowledge or actual knowledge of any copyrighted works being uploaded or shared on his website. So actual knowledge here means that court said you have to give specific URLs to the MySpace. And if after giving that, MySpace does not remove, then the MySpace will be liable, not otherwise. So this is how, harmonious interpretation of 79, 81, 51A subclause 2 was done. And if they do not remove or receive actual knowledge from affected party, mere general awareness is not sufficient. So affected party at least should give the specific knowledge that this is the URL. Why? What was the reason? Now, if I tell you the reason, that you have given a catalog. Now, firstly, I'm becoming a judge. That is not my role. Secondly, I may be violating the rights of others, those who have genuinely uploaded their copyrighted works. For example, there is a remix of the same, of the sound recording. Remix, if they look into the song of the super cassette and a remix on that, they will be removing not only the song of super cassette but also the remix, which is not where the copyright does not lie with the super cassette. So they cannot, their freedom is going to be affected. They will be violating, and there will be a number of disputes which the MySpace will be facing. So therefore, court said that there has to be some arrangement that is the specific URL. Just a second. All right, so I think this is clear to you. Let's move to the next slide. Now, these are again cases where ringtones were, there was a license to reproduce the ringtones, and when the incoming call comes, the ringtone has to be, is heard by people. So they wanted to have even royalties for that. The court refused for that purpose. Then they said there's no violation of ringtone when initially you have transmitted, because there was a license initially, and this is not that very zone who is violating the ringtones, the copyright. Please move further. This is another case where trailers of Disney movie was made, and they said this is somewhere, you are not only violating the reproduction right, but also the communication to public. So the two rights are getting violated simultaneously on the internet. Yes, next case. Now, these are the remedies which these are the remedies, 65A and 65B has been introduced in the Copyright Act, whereby anybody, if you are using a technology for access or for, copying, then anybody circumvents that technology, you will be, there will be a criminal liability to that. And also, if you alter some right management information. Can we move further? So what is right management information? That has already been defined in the Act, that is title, name, address, terms and conditions. These are all right. Can we move further? As regards the term of copyright, it expires, and you could find some of the website of the Project Gutenberg, where you have 75,000 ebooks which are in public domain. You will find it like Pride and Prejudice and Iliad. So next slide, please. Now, next slides. Yeah. Now, let me just explain this one, the fair use part. Now, this is a case. I just want to discuss I-paradigm's case. I-paradigm's case is relating. Yes, here. Now, this is a case. You all, whenever you submit your article, you go to the Turnitin, and then you see whether there is a plagiarism or not. Similarity check is done. Now, this is what plagiarism is doing. That whatever is uploaded, wherever they are checking this similarity, what happens that they fully upload the article in their website, and then compare. When next time you come up, then they compare with your article. Some other person comes, they compare your article also whether there was any plagiarism or not. So the students had filed case against this Turnitin that how you have uploaded without my permission my article when it was brought for the plagiarism check. So the court said that, and they said this is a copyright infringement. The court said no, this is a fair use because he is not making any commercial use of that. This is a transformative use and comes under the fair use, and this will not amount to copyright infringement. Can we move further? Yeah, there are some, these are the amendments which have been made in copyright law. That is, suppose there is a reproduction of the work on the RAM. This is a temporary storing, and that will not violate the copyright infringement, or you are providing some links which have copyright, like Google is providing links which has the copyright. So if someone complains, then he has to remove it, and otherwise you can show that link. And can we move further? Further, next. Now, as regards the owner, further, next. Next, you can read. Now, see, what I want to discuss here is that multimedia works, we still don't know who is the owner of that. So, if, the one who has, where there is artistic work, he is the owner, or one who has given the text like literary work, he is the owner. So, we are not aware of, this is something which is an ambiguous situation, that ownership lies in whom with the multimedia work. Can we move further? These are some of the exceptions which are there regarding the ownership, that if you use it in the newspaper or magazine, they will become the owner, or somewhere you are giving some work has been done for consideration. Can we move next? Now, this is the one, suppose commission work is there, you give some consideration for the work, like a website designer. So who will be the owner? We can at least apply this clause B, saying that the one who has given the consideration will become the owner, first owner of the website, because I am a company, I have given the consideration, not the website designer, but I should be the owner. So it can come under this exception. Can we move further? Yeah. Now, another important change which has come up in the copyright law is, Suppose, when you are assigning your work, in assignment, if your future work, no, when you are assigning it, the technology is not existing at that time. That is, the medium is not existing. And suppose you have given in print, and now the computer has come up and you can make the ebooks. So whether that assignment is for ebook also, because that medium was not existing. So the law here says that if the medium was existing, then it was different. But if the medium was not existing at that time, that assignment will not be for that very medium, that is for ebooks. Okay, can we move further? So these are about the licenses. It's there can be voluntary licenses. When you have, licenses for these books, etc., then there can be, special terms and conditions for your, let's say, the version which is in the ebook, or print version, it can be separate. So this is how you can incorporate those terms and conditions. And can we move further? Because this is licensing part and they might have already done. So the electronic rights also, you may have electronic rights that should be specifically inserted in your licenses. Yes. Then further, next. Yes, next. So again, the rights of the performers and broadcasters, they can also be violated. One of the example which I can take is the wrong websites which have come up on the internet. Like suppose somebody has been given rights to broadcast the cricket matches like Star Sports, etc. And then what will be happening, these wrong websites also start showing some of the element of these matches, and their addresses are not known. So the John Doe order is, or Ashok Kumar order is issued by the court to restrain them from telecasting. But the problem here is that if you say that this URL should be deleted, they will come up in use another URL and start broadcasting that. So this problem is still existing, and many cases have come up where courts have restrained these wrong websites. Yes, next. Yes, next. And here, international treaty, internet treaty is your WIPO performance and phonogram treaty and copyright treaty, which has introduced your rights management information and circumvention of technological measure. Berne Convention, as you all know, deals with copyright, Berne, TRIPS. Further, please. TRIPS. Yes, you can move further. TRIPS is also one of them. I think I had framed certain problems, but the time is not there. Otherwise, we could have at least discussed problem 1. Thank you so much. So this is a problem which you can think of answering if you want. If you have 5 minutes time, can read it. And what will be the answer of this? Please, we can discuss.
And also, ma'am, with your permission, can we have 1-2 quick questions?
Yes, please. No problem.
Dear participants, if you have any questions, you can unmute yourself and ask the questions, or you can put it in the chat box.
Krishna, I have shared you some questions. By the time you can put those questions if you have.
Yes, sir. Ma'am, there is a question from one of the participants. Aadhaar data breach 2018, a massive breach exposed the personal information of millions of Indian citizens. The scale of the breach raised serious concerns about data security and privacy. They wanted to know your views, ma'am, on this.
Yes, certainly, but this is certainly a very, I would say that not yet clear, because we don't have the data protection law. We do have the Data Protection Act, whereby we can go against these people. rules have also come up in the draft form, and judgments are there, Puttaswamy judgment, which says that whosoever the private parties or the government who is violating the privacy, the law should be there for them, because it can be violated by both, whether it is private person or private parties like companies, or maybe your let's say the government. So it's not that privacy is violated or your right is violated only by the government. Government can do that, and you can go proceed against government, but you can proceed against the parties also. There are provisions. There the board which has been created in the Data Protection Act 2023, and let's see how it comes up. But they can.
Okay, ma'am. There is one more question. Some cases have been resolved, many remain unsolved due to the complexities of cybercrime investigations and the evolving nature of cyber threats. How, as academicians, we can reduce this issue? What measures and how can our cybersecurity R&D accountable to these issues?
See, when we talk about cybersecurity, we do have provisions. Uh, when somebody is violating or committing the crimes, then in that case, the government or the courts can order for blocking. So we have a provision for blocking in the IT Act. Then, if some types of crimes are such that the intervention or interception of the government is required, where you may say that your privacy is getting violated, but no, just like in case of telephone tapping, you have to follow all the procedures. There are interception rules, and those rules are followed. And after following those rules, that is the rule of Telegraph Acts, Rule 419, they have to follow. There is a review committee who can cancel the order also, and order can be there for a limited period. So there are provisions relating to cybersecurity. Then we have certain who looks into the cyber incidents under the IT Act, and certainly problems regarding your an investigation. See, when I talk about the investigation, we need people who are expert in this areas of technology, digital technology, and there is a conflict, if you see, between the IT Act and your IPC, if there is a crime under the IPC or where any other. The conflict is that investigation under the normal criminal law, it is done by the person who is the level of the sub-inspector. And now when you see the IT Act, that investigation can be done only by the your deputy superintendent of, sorry, not deputy superintendent, inspector of the police. Earlier it was DSP. So you can imagine how can a person, if a sub-inspector is going, he cannot register the crime under IT Act because he is not entitled to. And inspector is the in charge of Thana. So generally what is happening, it is sub-inspector. This is one problem. Then there is a problem of evidence also, evidence collection. What happens is you have section 65B of Indian Evidence Act, and now the BSA, it is, I think, section 63 also. So in that case, you have to follow the procedure. So many of times, if that procedure is not followed, that evidence will not be admissible in the courts. So procedure is that the computer was working, properly, and when you were transferring the information at that time, and the computer was working properly, or the information was not affected, or information fed in the regular course, and then you have to give a certificate by a person in charge that regarding all these activities. Then what was the whether laptop was involved or pen drive, or what was the gadget which was used while transferring the information. So information was fed regularly, computer was used regularly. So many things are there. Apart from that, the certificate, if the certificate is not given by the person in charge, whatever you have collected, you are going and showing a video in front of the court, unless and until it is with the certificate, as per the procedure of section 65B, that will not be admissible. So most of the cases which are based on the evidence is not admissible, the problem will occur. What can the court do in that case? So these are complexities which they are getting resolved because they are training the people on this area, how the computers have to be used, how the forensics have to be done, how the investigation has to be done, how you have to transfer the information. They are getting trained, and slowly things are improving, as it was there in 2000 when the act was passed.
Okay,
Okay,
madam.
ma'am. Thank you. I had request Krishna to wind up the session since it is already past 1:30. And those questions that were unanswered, the mail ID of ma'am is there in the program schedule. You can kindly, I hope ma'am won't have any issue. You can kindly
No,
address
no
the
problem.
issues. She,
No,
yeah.
anybody can ask.
Yes,
No
she will
problem.
definitely provide it since the assessment is on by 2 p.m. So we'll have to wind it up by compulsory. Sorry, ma'am.
I'll be learning from those questions, so I have no problem.
Yes, ma'am. Sorry also, ma'am. We had to wind up at time
No,
because
it's okay. It's okay. No problem.
Ma'am,
Sometime else.
before we conclude this session, ma'am, on behalf of Department of Law and all other participants who have taken part in this FDP, we thank you, ma'am, for sharing your expertise on this IPR and cyber security, from basics to complex legal and technical issues involved in this subject, and also throwing light on aspects like trademark domain names, reverse domain names, and also procedure involved in the online marketing issues, everything focusing on this trademark and also copyright related issues also. Thank you very much, ma'am. The cases you have discussed help us in understanding the subject a little more deeper. We are hope we had more time to discuss that copyright issue also in more detailed manner. Thank you very much, ma'am.
Thank you very much to Mr. Barua. Thank you very much to whole of the team. Maybe next time we can interact.
Yes,
And
ma'am.
it was really a learning experience for me.
yes, thank you, ma'am. Would be very much pleasure to see you in physical mode also, ma'am. Thank you, ma'am.
Thank you so much. Sure.